Our government has to play by the rules, folks. They have a lot of rules in place in order to protect we citizens from a large government and all the power that they have. And one of those rules is the fact that your mouth can get you in trouble, and the things you say can send you to jail or prison. And I'm gonna talk about a case where the guy said some things and now he's serving life in prison. I've oversimplified things, I get it. But a recent Florida Supreme Court decision, state of Florida versus Zachary Pena. And Pena was charged with a couple murders, right? The police arrested him and they wanted to talk to him about it. And of course, like we said in so many videos, I ain't talking to you. I'm gonna remain silent. I would like an attorney. So Pena did all those things, and then he had some health issues. They took him to the hospital, right? Now, you know how this works. You've seen it on TV shows. He's locked to the bed, and there's some deputy at all times making sure that Pena doesn't leave or whatever. Well, in the course of this hospital stay, Pena chats up this deputy. And during this chattiness, what happened is Pena sort of incriminated himself, got charged with several murders, and got convicted and is now serving a life sentence for several murders. The issue is, what do you do when you know that you have chatted somebody up, they are saying incriminating stuff? Do you have to warn them that what they are saying can be held against them when you already told them this? And they already told you, I'm not talking without an attorney. And yet here Pena is talking to this deputy without an attorney. Pena's defense attorneys correctly filed a motion to suppress these statements on appeal after he got convicted. They won on appeal. The 4th District Court of Appeal said, well, you can't do that. You need to warn him again. You need to warn him for a second time that this stuff is gonna be used against them. This went all the way up to the Supreme Court because the prosecutor's like, I wanna keep this conviction for a couple murders and I don't like these statements getting kicked out. So the Florida Supreme Court chimed in recently and they said, you do not have to automatically read Mirandas again and again and again. The man was read his Mirandas, he understood the warnings, he wanted an attorney at that time, and now later he decides to talk. I think it is best practices that we citizens get read our Miranda every single time. I really do. But the Florida Supreme Court backed off that rule and said there is no hard and fast rule. I think the lower court, when they overturned this, felt like there's some hard and fast rule that you have to read Miranda every single time. And the Florida Supreme Court said, let's look at the totality of the circumstances here, folks. And the totality of the circumstances is that this was a voluntary discussion. This was a voluntary waiver. This is not a constitutional problem. And we are not going to suppress these statements. So just to let you know, folks, Miranda is not automatically read every single time somebody opens their mouth. This can go against the government, okay? Florida Supreme Court is not saying that you can get away with this as a law enforcement officer every single time. But under the totality of these circumstances, in that hospital room with that conversation, they said, no, this is fine. We're gonna let these statements in. You get to keep serving your life in prison for murder. And that's kind of an update as far as Mirandas go. So there you have it.